Hello, everybody, and welcome to our Week 5 lecture. This week, we're going to be talking about collective bargaining in California. We're going to be looking at the state of California legislation over the last 60 some years. And then we're going to be looking at the U.S. Supreme Court landmark legislation, the Abood versus Detroit Board of Education, and then the now famous Janus decision, the landmark decision that overturned the Abood decision prior. So again, this week's topic is collective bargaining. And so again, we know what collective bargaining is, right? Basically, collective bargaining in a nutshell is unions, right? That's what unions do. They're intended to bargain for their workers, to bargain for workers' wages, rights, working conditions, contractual agreements, what have you, right? So that's what collective bargaining is, and at least that's what it's intended or should do, right? So this week's discussion is based on Chapter 6 of the Najida book, right? We only have that chapter for this week, but it's a long chapter and it's a dense chapter, right? It's not the best and most enjoyable reading, right? But it is what it is, right? So rather than spending too much time on the chapter itself, I thought it was important to focus on other things, other related aspects of this week's topic. But I did want to spend just a little bit of time on the chart that Chapter 6 has, and you can look this up in Chapter 6 of the text, and that's the chart that shows us the historical development, the description of the California legislation. Going back to 1957, the Los Angeles Metropolitan Transit Authority Act, this basically began the history of labor unions in California, right? The right to labor organizations, right? And to engage in collective bargaining. And of course, the 1959 Firefighters Act, this was very important. By the way, the 57 Act affected transit employees. The 1959 Firefighters Act affected state and local firefighters. And so, different acts affect different groups. In the 59 Firefighters Act was very important because it gave the firefighters the right to organize and be representative for purposes of looking at grievances, right, or fixing grievances or addressing grievances against them. So the workers now had the right to defend themselves against grievances, and also provided recommendations as far as wages, salaries, work hours, and other working conditions. And so this piece of legislation was very important because it was much more expansive and specific. And you had other future legislation, right? The George Brown Act of 1961, which was repealed in 1990. Continuing on, we had the 1965 Winton Act, the 1968 Myers-Brown Act, and 1975 Educational Employment Relations Act, known as the Rhoda Act. Okay, so these are some of the key historical pieces of legislation for California as far as its bargaining laws. Now, federally, right? When we talk about collective bargaining, especially now, we cannot stray too far away from what has happened federally, meaning what has happened with the Supreme Court, because perhaps the most important and transcendental legislation that has affected collective bargaining in the United States has been two cases: the Lewis Abood versus Detroit Board of Education case, 1977, and then the Janus case, which we'll talk about here in a minute. So the Abood versus Detroit Board of Education case was basically about a school teacher in Detroit Detroit's public schools, right? So this school teacher, um, Louis Aboud, he did not want to pay union dues for this union, this organization that he thought was spending money on candidates, political candidates, that he did not support. He felt that that was not fair and that was not something that represented his views, and so he sued the state of Michigan. He sued Detroit Board of Education in a state of Michigan court, and after the due process in the state of Michigan, and the case eventually ended up in the Supreme Court. The Supreme Court ruled in a 6-3 majority decision that non-union employees in the public sector could be required to fund union activities related to collective bargaining, contract administration, and grievance adjustment purposes. This, of course, was a blow not only to Mr. Aboud, but also to the workers' rights versus the rights of the union. And this, of course, gave unions tremendous power, tremendous collateral as far as being able to collectively or negotiate with workers and pretty much set the rules as far as the worker employer relationship is concerned, right? So this gave unions tremendous power, and of course necessarily limited the ability of workers to decide on such matters that had to do with their employment and the conditions for their employment. Okay, and by the way, the Supreme Court unanimously ruled 9-0 against union shops, which union shops means it's the idea that you have to belong to a union in order to work. So they voted, they ruled against that, but they did say that if you didn't belong to the union, you could work and still and not belong to the union. You were not forced to belong to the union, but the union could charge you for those union wages or union fees, because under the claim that those fees were going to fund the collective bargaining, contract administration, and grievance adjustment purposes, which benefited, or at least could benefit, any worker, including non-union workers. So that was the justification. So this is 1977, of course, in decades past, and recently, right, in 2018, a landmark decision, the Janus versus American Federation of State, County, and Municipal Employees Council 31 decision. This was 2018, and by the way, the date is important, right? We'll see how that is important here in a minute. But the Janus case overturned the Aboud case. Now, it's important to note that before the Janus case, there was a prior case, the Harris versus Quinn 2014 case. And in this case, this also went to the Supreme Court, and the Supreme Court held in 5-4, very narrow 5-4 decision, that non-union workers who were paid by the state of Illinois to provide personal assistance, right, to provide services, could not be required to make service fee contributions to a union to help fund its collective bargaining activities, because they were not, quote-unquote, full-fledged public employees. So while the reasoning behind the decision was different than the Janus case that we'll see here in a minute, it was an important step that kind of opened the doors for the Janus case, because it told the state of Illinois that you cannot require these people to make these service fee contributions. So once you created that opportunity or that option to not require them, it not directly but somewhat indirectly kind of it affected, or it basically said the opposite to what the Abood case was saying, right? Now, the court did not overturn the Abood case at this time. Okay, it severely criticized the Abood decision, but it did not overturn it. And that's important because in 2016, Justice Antonin Scalia passed away, and the court ended up with 4-4, right? Remember, the Supreme Court had a vacancy, and the vacancy was not filled by President Obama at the time. And, of course, the debate, right, and the controversy about, and now even more so, right, after what happened with the last Supreme Court justice to be appointed by President Trump. Amy Coney Barrett. So the point of the matter is President Obama did not appoint a Supreme Court justice, which he had every right to do, but he did not do so. And of course, there's political reasons. There's reasons. Obviously the Senate, a Republican Senate at the time, Mitch McConnell, right? The politics of the issue, but in the end, we had a 4-4 court, and that 4-4 court did not do anything to overturn the Abood case, right? The Abood. In fact, smaller cases, less known cases were brought up in federal district courts and in other lower courts, and even those cases even provided more support for the Abood decision and for unions, and less support for the workers, right? All of this, however, changed drastically with the newly appointed conservative justice for the United States Supreme Court. Justice Gorsuch was nominated and appointed eventually to fill that empty spot. This was in 2017 by then newly elected President Trump. But had President Obama, who had nominated Merrick Garland for justice, had he been able to go through that process, he would have been the ninth justice to fill the court, and perhaps the Janus decision would have been different. And so it's a decision that is controversial, without a doubt. Nevertheless, the decision is important. It's very important because it did overturn the Abood decision, and it overturned it on a First Amendment principle. And this is important because when we're talking about First Amendment issues, the state has to use its strict scrutiny test, and strict scrutiny test basically says that the state has to prove that there is a compelling interest. There is a compelling interest to restrict a First Amendment right, right? And if it does not show proof, and it cannot convince that there is a compelling interest sufficient and compelling enough to merit the restriction of a right, like the freedom of speech right of the First Amendment, then the court will side with the First Amendment right. And in this case, this is Mark Janus. Mark Janus was a worker for the state in the state of Illinois, and his argument was that he was being forced to pay for fees similar to Abood. He was being forced to pay for these fees when, in fact, this union that he was working for was supporting a a position that he was not supporting, and so he felt that he was subsidizing a politically driven and a position that was not consistent with his, and he felt that that violated his First Amendment right, because in fact what it did was that not only was he paying to support and subsidize another voice, right, the voice of the union, which was not in concert with his voice, but the fact that he didn't have a choice to leave the union and still maintain his job limited his First Amendment right, because he did not have that choice. And he believed that it was fine as long, if you wanted to join a union and be in the union, and if you supported whatever the union's political position and agenda was, then that was fine. But that you should have the right as a worker to decline not paying those fees if your views were not consistent with those of the union. The Janus decision basically did away with the fair share agreements principle, right? Which basically said that workers who are non-union workers should still have to pay these fees because the union defends their right, regardless whether they are in the union or not. The fact that the union defends them and has to pay money and has to promote their collective bargaining and grievances, right? Everything that supports the worker. Even if you're not in the union, you're still going to benefit from that. And so the union felt that you should still pay for that. Well, the Supreme Court held that by doing that, the state was in violation of the First Amendment protections of free association and freedom of speech, which is what Mr. Mark Janus was alleging. So a very, very important landmark case. So what was the impact? What was the impact of the Janus landmark decision? Well, it's very interesting to think about the impact of this decision, because you would think that the union enrollment, right, union membership would drop, and this is something that was kind of expected. And many experts said, this landmark case is going to lead to the decline of unions, and unions are going to be very, very affected, and you're going to see people leaving the union, and also this is going to have a tremendous financial impact on unions, right, which is going to lead to a loss of union power, especially political power. But oddly, if you look at since the Janus decision to the present, you see that it's actually not been exactly that way. It's interesting that union membership has dropped. Yes, it has dropped, but as far as financial losses, you haven't seen this, because what's happened is states have become much more proactive in trying to get workers, quote unquote, into the unions, right? Trying to lobby for union membership. Unions have also they've upped their fees, right? They've increased their fees on labor union membership fees, and so for those union workers, those are now paying more as far as fees, right? And so financially, the unions haven't suffered as much as was expected. Now, if you think about it, for those that want to be in the union, it's fine. If you want to be in the union and you have every right to be in the union, then, and if you want to pay those fees and the union is providing a service that you are happy with, then by all means continue to be in the union. And if you don't mind paying the higher fee, then pay the higher fee. but you shouldn't be forced to pay a higher fee or pay a fee if you are not happy with the service, or if you don't if your views are not being represented by the union, and the union is not doing what the union should be doing on your behalf. By the way, the Janus landmark decision also impacted the private sector unions as well. So this was also big, because not only was this affecting public unions or public government unions, but it also had the same treatment for any union, private sector unions as well. You cannot force workers to pay those fees. So this was big. This was definitely big. Now, for your assignment, okay, for your assignment this week, one of yours, because you also have the entry, right? But for the presentation assignment, you are asked to identify a specific public employee union. So what is the name of the union? Obviously, what is the region of the union? What do they represent? Okay, and then, has anything changed for the union since the Janus decision, since the Janus case was decided? Okay, try as be in detailed as possible. Why has it changed, or how has it changed? Okay. Identify a minimum of one academic peer-reviewed journal published recently that discusses public employee unions. You can go to the Cal Baptist Library. You can also go to Google Scholar. Go into Google Scholar, and once you're in Google Scholar, link with Cal Baptist University, and then you can look in there and find peer-reviewed journals, collective bargaining. And you should find several that include works, articles that deal with this issue. So provide the article citation in APA format, and then also, what were the main key points, or the main points that you took away from the article, right? So once you kind of peruse the article, what are the key points? Identify a minimum of one news story that discusses the Wisconsin Act 10 bill in 2011. All right. And by the way, remember that the Wisconsin Act 10 affects collective bargaining, compensation, retirement, health insurance for public sector employees. Okay, so identify a minimum of one news story. And then number 7, what was the source, and what was one thing you learned from the resource you didn't know before? And then how does that story relate to this week's material? And then lastly, remember to keep your presentation to 3 to 5 minutes long, right? Not more than 5 and a quarter, please. Upload it to Vimeo or YouTube as you've been doing, and you've been doing a great job, and then embed it into the discussion board. Okay, so that's the assignment, and the assignment is basically based on that very important Janus landmark decision, and of course the Wisconsin Act 10. So some takeaways, key questions to ponder from our discussion of collective bargaining, and especially from the landmark Janus case. Think about, did Janus have a legitimate First Amendment argument? All right, so I'm not gonna answer these questions, but think about these questions, right? Think about these questions as you think about Janus, and as you think about California's legislation on collective bargaining. What should be the role of labor unions, right? Is it collective bargaining, or is it something else? Ask yourself that question. What are labor unions doing now? You know, what are they? Are they really promoting workers' rights and fighting for wages and fighting for better working conditions, or are they now involved in other activities, right? In 2016, public employer unions contributed $65 million to political campaigns, and 90% went to Democrats. So without getting partisan here, that's a significant finding. It's a significant piece of information. It's $65 million is a lot of money, and 9 out of 10 dollars went to Democrats. So this is obviously a political issue. This is obviously a partisan issue that obviously it doesn't take a rocket scientist to figure out that Democrats are therefore very much pro-union and Republicans are not. And so, as we have seen with many things in today's political landscape, unions are no different, and collective bargaining is now part of that political discourse, right? And like everything else, it gets politicized, right? And so, again, going back to question 2, what should be the role of labor unions, and are they still consistent with their original role as labor unions, or are they now something else? And then lastly, what does this mean for the rights of states, and like California, for example, vis-a-vis the federal government, right? If you think that more than half of U.S. states are right-to-work states, and this means that the right-to-work states are those states that do not require, okay? A right-to-work state is a state that does not require union membership as a condition for employment. However, California is not one of those states, okay? So if you think about what this means for California versus, say, the rest of the country, and what does this mean for the future? Well, you can still see that while Janus significantly reduced the power of unions in the United States, that reduction in power is still being challenged by states like California with their own legislation. Right, California is not a right-to-work state, and so the benefits, so to speak, of Janus are still limited by some of the state legislation that California has. Okay, so again, thank you very much. I hope you enjoyed this lecture. I hope you found it interesting. Enjoy the assignment, the presentation, and also your entry. And again, as in every lecture, I wish you a great week, and God bless you. Thank you very much.